Hello and welcome to the Clark Hill panel on the Biden administration's executive order on the safe, secure, and trustworthy development and use of artificial intelligence and what the executive order means for data privacy. My name is Myriah Jaworski, and I'm a data privacy attorney with Clark Hill, where I also co-chair the firm's emerging technologies and artificial intelligence team. We have a very esteemed panel joining us today. And before I introduce them, I think it's important to make the typical attorney disclaimer that the views expressed by today's panel are our own. They do not represent the views of our employers, our clients, our colleagues, etc. So first up, we have Soribel Feliz. Soribel is a thought leader in the fields of responsible artificial intelligence and emerging tech. Currently, she serves as the Senior AI and Tech Policy Advisor for the United States Senate, where she advises the Senate on emerging technologies with an emphasis on AI, data privacy, and the intersection of AI and health, education, and labor. Previously, Soribel worked for the Trust and Safety team, within the Content Regulations Department at Meta, and before joining Meta, she was a Foreign Service Officer with the United States Department of State. Next up, we have Dr. Divya Sridhar. Dr. Sridhar is the Director of Privacy Initiatives at the Better Business Bureau's national programs, where she works on the design, development, and launch of multiple industry self-regulation programs, including oversight of the EU-US Data Privacy Framework Program, the Global Cross-Border Rules Program, the Digital Advertising Accountability Program, and the Digital Health Privacy Program. Dr. Sridhar has served in numerous capacities at think tanks, private companies, and not-for-profits. She has written books and authored publications in the fields of tech, privacy, and public policy, and she holds her PhD and master's degree in public policy and finance. And last, we have Carole Piovesan. Carole is the co-founder and principal at Inc. Consulting, where she focuses her practice on privacy, cyber readiness, data governance, and artificial intelligence risk management. Carole plays an active role in shaping data law, policy, and standards in Canada and globally. She's a member of the OECD AI Policy Observatory, and she's contributed to numerous organizations, including the Global Partnership on AI, the Global Task Force to Promote Trusted Sharing of Data at the German Marshall Fund of the United States, the Standards Council of Canada's Data Governance Collaborative, and the National Advisory Council on AI in Healthcare. Welcome, everyone. All right, so a quick overview. 2 weeks ago, the Biden administration issued what, by its own account, was a sweeping and broad 111-page, 20,000-word executive order on the safe, secure, and trustworthy use of artificial intelligence. For those who've not read all 111 pages, the order is available on whitehouse.gov on the website. But before we jump into sort of what the order looks like and what it means for data privacy, for those joining internationally and a refresher for others in the audience, what is an executive order and sort of how far can this EO really go? An executive order is a mechanism by which the president can manage the executive branch. The president has the authority under Article 2 of the Constitution and pursuant to different federal statutes to essentially direct the federal agencies, such as, for example, the Department of Commerce, to take certain actions. And then we also have what we call the independent regulatory agencies. So that's going to be the Federal Trade Commission, the FCC, the Securities and Exchange Commission, and the president cannot directly require that these agencies take any actions, but can, as we see in the order, sort of encourage and nudge these independent regulatory agencies in a certain direction. And lastly, we got a question at the outset of the registration, and that is whether the executive order can be overturned by a future administration. And the answer to that is theoretically yes. An executive order, it's reviewable by federal courts. So federal courts can take a look at the order. They can evaluate whether the order was within the scope, the president's constitutional and statutory authority. And then a future administration can revoke or rescind or modify the executive order. All right, so that's an EO generally. This EO in particular, it's comprised of an introduction and a preamble section, a definitional section, which includes some very useful definitions and terms that I highly recommend anyone in this space, take a look at and spend some time with. We're usually sort of struggling just for those foundational definitions of artificial intelligence systems, et cetera. We've got NIST, we've got other standards, but at this point we have the order sort of endorsing its own view on what is AI. And then we have 8 objectives that are identified. Those objectives include promoting responsible AI innovation, supporting workers, building out sort of the federal AI governance competencies, and then, of course, protecting privacy. In fact, the term privacy is mentioned no fewer than 38 times in the order. In addition to that standalone section on protecting privacy, there's a discussion of privacy harms that's really weaved into the order, into the order's discussion of civil liberties and non-discrimination, into the order's discussion of sort of encouraging privacy principles during the software development lifecycle of AI tools, and a discussion of sort of having federal agencies look at how they're collecting and using personal data and the potential impact that might have on personal privacy. So on whole, it really reflects what one White House official has called a pull every lever strategy to meet both the opportunities and the challenges of artificial intelligence. The order is very much a promises and perils document, right? It stakes a claim for the United States to be a leader in the advancement of artificial tools and technologies, but it also acknowledges the very real risks of AI systems and requires federal agencies to take a look at and regulate those risks. All right, so we talked about what an executive order is and how this order is framed up. I think the one last point before we jump into our panel discussion is that because the order is really the president directing the federal agencies to take certain actions, the impact on private business will be limited and a little bit more indirect, right? So there's 3 main ways that this order will impact private businesses in the United States. The first is going to be through the federal procurement process. So if your organization is a contractor to the federal government or a subcontractor to a contractor, certainly AI standards that the government endorses or requires will be pushed down that procurement pathway, if you will. So the power of sort of the federal agents, the federal government's procurement and purchasing power, we may see some downflows of AI standards. The next is we're going to see some promulgation of rules by the various federal agencies as it pertains to the use of AI tools and technologies in their space. So kind of industry by industry or sector by sector. And during that rulemaking process, there will be an opportunity for private businesses, for individuals even, to comment on the proposed rule. So that's going to be the rulemaking process. And last, and perhaps most interestingly and excitingly as it pertains to privacy, there is some funding opportunities available. So we're going to do a deeper dive on privacy enhancing technologies. And that's one of the areas that the order sort of focuses some substantial attention to and allows for some funding and award opportunities there. All right, so that's the executive order. The issuance of the order is very much distinct from congressional activity or legislation. And when we think about Congress, and Soribel, I'm looking at you, the old knock on Congress is that when it comes to technology, Congress is behind, right? Certainly big tech and social media. But in the AI space, Congress has been quite active over the past year with various committee hearings, the Schumer Insight Forums, et cetera. So Soribel, as the senior advisor on AI and tech policy for the Senate, you have real on-the-ground visibility into this process. Can you kind of describe how Congress has focused on artificial intelligence in the lead up to the order? Any collaboration between the administration and Congress and sort of how the order is being viewed on the Hill?
Thanks so much for having me. Congress has focused on AI very much so since the release of ChatGPT. And keep in mind that Congress can be a reactionary institution, and so they react to what's going on in the world, right? So for example, when you had crypto, they were very much reacting to crypto as well. But I have to say, I have to give it to Congress. It's done a great job of really going deep into studying AI and studying the consequences of AI. So Congress has done a few things. One, a group of staffers went to Stanford University a few months ago to spend a week there and be educated on AI. Senator Schumer, as you know, has put together, I believe it's 9 AI Insight forums, and I've been to all but one of them. And I can tell you that even though they're not open to the public, they are, they have all of the stakeholders that you can think of. You have civil society, you have interest groups, you have industry, you have NGOs, academia, you have all types of stakeholders. And I'm very proud to say that I think Congress is doing a great job of that. You also have civil society stepping in and sending in tech Congress people, AAAS fellows. I'm a AAAS fellow myself, and I work exclusively on AI. So these are fellows that come to Congress to work on AI, to work on tech, and we are basically free labor, but we have very specific expertise on tech issues. There's a lot of committee hearings and a lot of briefings going on. A lot of people sending white papers, responding to RIFs, to letters from congressmen and congresswomen. There's a lot of industry meetings. There's a lot going on. And last week I went to so many, and there's not enough time to go to all of them. So Congress, I think Congress is doing a really, really good job of keeping the public informed, of educating members, educating staff, and I hope they keep it up.
How is the order being perceived on Congress? So is the order sort of like a wish list of what future legislation would look like? Could it be leveraged as a model?
Yeah, as you know, the order is an executive order. It has no enforcement mechanism. It has no teeth, right? So it doesn't replace legislation. But I think it's an awesome model for legislation. It's very comprehensive. It touches on all aspects of AI development and use. It really calls for multi-stakeholder engagement, which is already being done in Congress. And I really appreciate that industry and academia and civil society are all in the room and at the table. It also takes a risk-based approach, and so it's hoping to not stifle innovation. It only focuses on the highest risk, and I think that's awesome because we want to keep our lead on AI. It really stresses transparency and accountability, which is very important. It calls for funding, a lot of funding for research and on AI safety and on security. And it's also a way to ask not just Congress, but the federal government itself to get it together on attracting a tech savvy workforce and to ensure that we have a supply of smart, brilliant, talented people who are not US citizens but want to come here to study and want to stay here. And, as a former State Department employee, I'm very familiar with all of the visa changes that they want to make. And I applaud that. I think that would be very, very beneficial to the United States. Finally, I'm just going to say that it also calls on us, on the Department of Education, on NSF, on our universities to attract US citizens into this STEM careers and technology careers because we can't just rely on high skill immigration. We have to push our own citizens to step in and step up and take these jobs that are so important to our future.
Certainly, the workforce development and building out the sort of competency of the federal government was a main takeaway of the order. One of the questions that we got in registration, Soribel, that I think you're really well positioned to answer is, as a business, short of hiring a government affairs official, short of directly sort of lobbying and engaging on the ground on the Hill, what are other things that businesses can do both to educate members of Congress to set the stage for potential future legislation, but also you've discussed so many different resources. How can businesses avail themselves of any of these hearings and all this information and gathering that your team has been working on?
Yeah, that's a very interesting question. And I know there's a lot going on, and it's hard for businesses to kind of parse what's hype, what's important, what's not. I would say businesses should focus on, they should take the same approach that Congress takes, right? Do it by committee. So if you're a health startup, look at what the health committee is doing and saying. So the health committee is the Health, Education, Labor, and Pensions Committee. So anytime there's a hearing, a congressional hearing at the health committee talking about health, you should be tuning into that. If you are an education startup, anytime there is an education focused hearing, tune into that. Um, also, if look at the members that are working on certain things, like for example, my member is very big on privacy and on health. So look at those members who are big on those things, who have a specific topic that they're known for. Follow them, see what they're doing. Um, and also look at what's coming out of agencies. So, for example, if you're a business that's catering to the federal government or to state and local governments, look at what they're doing, what they're putting out. If you're catering to the New York City government, look at the AI stuff that they put out. And I think that will help you focus because you cannot keep up with everything that's coming out about AI.
Agreed. And that's actually a great sort of segue to this conversation around privacy, right? We said at the outset that privacy was one of the 8 objectives identified by the order, protecting privacy. The order expressly acknowledges that artificial intelligence makes it easier to extract, to identify, and exploit personal data. And it also, according to the order, quote, heightens incentives to do so because companies use data to train AI systems. And in addressing privacy, that in that section in particular, the order does 3 things. First, it expressly calls upon Congress to pass a national data privacy legislation, and we'll talk about that on the sort of back end, particularly actually as it concerns child's privacy. The order also directs agencies to look at their own data collection and use practices. This is the commercially available information and some of that other discussion, and it offers or sort of encourages those independent regulatory agencies that we talked about, the FTC, the FCC, to use the full range of their authorities to protect consumers from privacy invasions and other AI harms. So really telling essentially Lena Khan and her staff over at the FTC, we like what you're doing, keep it up. But then third, the order really doubles down on the role of privacy enhancing technologies and the role that PETs or pets can play to advance safe AI. And Dr. Sridhar, this is where I really want to engage with you. I know your team has done a lot of work on pets, a lot of work kind of on encouraging the use and development of these types of technologies. But for our audience, let's start at a really foundational level. Like, what is a privacy enhancing technology? Can you give us some examples?
Yeah, absolutely. Thank you for having me. So I'll start off by saying, just based on my background, I'm steeped in public policy and government affairs. I like to look at issues as policy problems and then think about the technology as a solution and the governance mechanism that will ultimately help make that possible. When you look at the policy problem here, over 70% of countries globally have data protection regulations that limit the ability to share data and to conduct critical data analyses across borders. And that has a tremendous economic impact. These regs are not consistent either. So the regulations that are across the world, they don't necessarily align perfectly. And this year, of course, we've seen numerous states step in the U.S. and pass comprehensive consumer privacy laws that definitely fundamentally adds to the patchwork. So here's where pets can unlock a potential policy solution. And let's back up and let's talk about what is a pet, but I wanted to provide that foundation first as the policy problem and be considering the ultimate kind of framework for this. So pets are techniques that use cryptography and statistics to minimize the amount of identifiable personal data processed between entities while still ensuring accuracy in the measurement and analysis of the data. Common pet approaches include homomorphic encryption, anonymization, and differential privacy. So you may have heard of some of those techniques, which provide additional protection by never revealing personal data in plain text. Now, with all of that being said, I am a data scientist, and I recognize that our audience, we have plenty of lawyers, we have engineers, we have a broad range, maybe some early privacy professionals, and maybe some AI folks that aren't really well steeped in privacy. So let's talk about examples that can kind of give you a concrete understanding of what a pet is and how it's being used in a just a very real world context. So in the public sector first, you'll see excellent documented use cases of pets by the US CISO, Department of Homeland Security. I just went to a conference two or 3 weeks ago where Mason Clutter was talking. She's at the Department of Homeland Security. She was talking about the use of pets for digital identity and verification in the context of immigrants and citizenship. So very interesting use case there. And then the Department of Transportation is also streamlining their practices with regard to real-time shipping and those transactions that are happening with the private sector. Then when we think about private sector, right? So what are some of the examples of just common businesses that are using pets in our everyday lives? Google is a great example of this. And I just was made aware of this a few weeks ago at a different conference where I saw these obvious examples that I had never thought of for pets. A couple of them are Google Trends, Google Incognito Mode, and Google Maps. So let's zoom into the Google Maps example. That's a great one. So you might have seen on the Google Maps app the insights that are generated about the peak times when you should visit a restaurant, when it's either too busy or when it's much slower, and that's probably a good time to go. That data is calculated using the power of pets. So consumers aren't being directly tracked, they're not being identified, but in using the data that's being shared between Google and a business that might be the restaurant or might be a third party, that data is then being reflected, and consumers have a better understanding of those calculations and those optimized predictions and trends. So great example there, and definitely take a closer look. Google has a ton of resources about how they use their specific pet methodology. A few other sectors, just to know, where pets are used: financial crime and anti-money laundering efforts, and also in the high-risk clinical data trials and healthcare sector. We're seeing a lot of pet usage there. So currently in the US, we're seeing much more streamlined usage of pets in the high-risk sectors. But I wanted to share the Google example because it's fascinating to see consumer data being shared using pets and providing some good examples. Two other real quick shout outs. So Center for Information Policy Leadership, they were at the IAPP's Privacy Security Risk Conference a few weeks ago, and they had a number of great examples. They're coming out with a report of exactly this. What are some of those common use cases for pets, and how can other companies be thinking about using pets and adding that, leveraging that into their workflow going forward? Finally, the advertising context, super interesting. I'm going to shout out to one of our companies that we work closely with, Anonym. They've leveraged pets in really interesting ways, going to talk through that. And they actually also testified in Congress this year about the potential for pets. It was either this year or last year, but they testified. I think that makes them a fascinating leader in the space. So with regard to advertising, what Anonym has done is they've used a combination of pets, such as encryption, trusted execution environments, and differential privacy to help brands reach the right audience. And that way, the two B2Bs, the two businesses can actually share data about their consumers and more effectively advertise to those consumers without compromising the individual privacy. And so that's really a great example. And we're seeing a lot more of that in the advertising context, especially with the deprecation of third-party cookies and all of these other trends that are happening globally. So just a few examples there, but unfortunately, pets are an underutilized solution to a myriad of privacy
And why do you think that is? I mean, I do agree that when I've had sort of in-depth conversations around pets historically, it's always been in the ad tech realm as kind of a solution for the cookieless future, right? But there's certainly other, as you mentioned, other use cases for pets, and they do feel underutilized. Why, do you think that's a lack of information, lack of funding? Does the order address that at all? Any thoughts on that?
Yeah, it's a combination of things. So Gartner has some research out there, and again, I'm a data scientist, so I like to look at the research and provide that when I'm framing these issues. 60% of large organizations will be using one kind of pet by 2025, so that's coming up in 2 years. I think where there's a bit of a gap with regard to the information gap with regard to pets is a combination of places, and the EO, I think, the executive order kind of helps come in and solve for that in a way by spearheading the conversation and really helping companies come to the forefront about what the federal government is already doing. So obviously industry should step up and do so as well, right? Where I think there's some interesting opportunity is the fact that the US regulatory landscape has not fully caught up with the rest of the world. And because of that, it actually helps companies that aren't already, there's no red tape around pets, at least right now in the US. And that really is beneficial for companies that are looking to adopt and potentially innovate using pets without, having to worry about unnecessary restrictions or unfortunate regulations that are kind of undermining their potential. So there's a lot there that we can get into with regard to the regulatory landscape, but we know that in the US, the state consumer privacy laws that have passed, they primarily define anonymization and pseudonymization and de-identification, but they stop there. They don't really go into exactly what is a pet and what are the different use cases for pets and how they can play well with the AI ecosystem in order to really generate more market potential. So tons of potential there. Regulations kind of stop short of providing the green light, but the EO has done that, I think, and has helped move that marker forward for companies for 2024 in the right direction.
So, and that's a great point. And so if I'm a business and I'm definitely interested in utilizing pets or at least evaluating some use case for pets, right? What's the regulatory landscape? I think you're absolutely correct. We get this inquiry all the time. It's de-identified, it's aggregated, et cetera. And, even organizations that are sort of fall under the HIPAA umbrella and actually do the de-identification by the very stringent HIPAA standard. I don't think that there is enough confidence outside of the HIPAA realm in de-identification, right? Do pets offer a solution for that? What's the regulatory structure around the use of pets in the United States currently?
Yeah, that's great. And actually looking to the UK, the US can learn some really important best practices and lessons. The UK has been, kind of a front runner on this issue. They published guidance, I believe it was earlier this year, with a series of 8 categories of pets and the recommendations that organizations can take to adopt pets over the next 5 years. So that's a very helpful kind of timeline and approach. The UK's Financial Conduct Authority recently piloted the Tech Sprint initiative, which is focused on firms with synthetic data. They found value in leveraging pets in the anti-money laundering and financial crime space. So another great example for companies in that particular sector. And we can look to the rest of the world as well. Like I think Asian markets have been particularly interested in pets. Singapore's Personal Data Protection Commission is a great example of that, where they've tested sandboxes where companies can come in and not feel that, again, that tension between the regulations and where they should be experimenting. And so the more that the US can play in that space, I think that there is opportunity to really push forward and make an impact. And this is where I think it's a good plug for BBB national programs. We are right there trying to help companies feel more confident about what's in the regulations, what's not in the regulations, or the guiding principles in the state consumer privacy laws. And then what are the best practices that companies can demonstrate right now in obviously where the laws are silent, to demonstrate that they're good actors to regulators and consumers, and kind of quiet down the conversation about regulation in the space. Maybe we don't need to regulate, right? And so rather than chill innovation and create too much regulation in the space, why don't we look to third-party accountability programs like BBB national programs that can really provide a unifying voice across industry, regulators, and consumers. And by doing that, we can, again, steer off the heavy-handed regulation and offer a policy solution so that we can be that demonstrator of good best practices. And so that's exactly what we've done. We're thinking about 2024 to launch a potential program, maybe a pledge program to help companies across sectors think about all of those best practices that would be unifying, and look at those best practices and ensure that companies that want to be considered trusted pets would really be able to live up to the expectations in those best practices. And then, of course, as BBB national programs, we would provide a seal and provide the verification and offer that opportunity to companies so that they have that voice in the marketplace to support them.
That's excellent. And I'd be remiss before we move on to data provenance. I want to talk about synthetic data. You raised it, and I really want to close the loop on sort of the relevancy of pets to AI, right? So when we think about AI, what are we really thinking about? We're thinking about massive data sets, oftentimes massive amounts of personally identifiable information. And I think there's a lot of confusion as to whether or not you have the proper consents, authorizations, potentially license to use the personal information, for AI training, AI modeling, et cetera. So how can synthetic data, first of all, what is synthetic data? Second of all, how can synthetic data and other pets sort of provide a solution to this problem?
Yeah, absolutely. We saw the use of some of this data. Well, synthetic data just allows for an additional data set to enter the broader data, the data usage chain, and you inject that in order to be able to provide a more streamlined way to look at the big picture and be able to provide insights. And then with that being said, I think where we've seen the usage of some of these unique pet techniques that have really demonstrated performance for an AI ecosystem has been with regard to the US-UK Pets Price Challenge. So at the tail end of 2021, President Biden announced the US-UK Price Challenge on pets, and that's being advanced by the US NIST, National Science Foundation, as well as the former UK's Department of Digital, Cultural and Media and Support, which is actually now Department of Innovation. But basically, the two countries, given their shared democratic values and alignment on digital strategy and growth, decided to pool their financial investments toward this $1.6 million Pets Price Challenge. Getting to the AI part, but I wanted to set that up. So the structure of the challenge was that it was free to enter for any company that wanted to participate and compete for the funds. It took a multi-stage competition approach involving a white paper submission, prototype development, and a red teaming phase. And then participants could select one of two tracks. So one track was a financial crime prevention track, and the other was a pandemic response and reporting track. Again, that was just the time when we were all kind of coming out, emerging from the pandemic. The winning solutions were acclaimed academic institutions, and no shocker here, but they combined different pet approaches. I believe synthetic data was one of them, to allow the AI models to learn to make better predictions without exposing sensitive data. So you can see that, I picture AI being this broader umbrella of different kinds of tech and different solutions, including machine learning, including other, data that we aren't talking about now. And pets are one of those, particular solutions that incorporate different types of techniques, data analysis techniques, and are part of that broader AI umbrella. So I do see that, there's going to be a lot more emphasis on this year, especially since there's been a ton of buzz around AI, and it's going to continue into 2024 and beyond.
Carole, I'm curious in your take on PETs.
We do have some experience with privacy enhancing techniques. Still a very robust discussion about PETs among the privacy community. There are a number of different techniques, not one of which seems to be winning the privacy debate. I've often talked about, can we get a technical solution to the policy problem of privacy in order to enable the use of that data for AI development and training purposes. We are certainly seeing more attention being placed on synthetic data, but also quite robust debate about some of the limitations of that data, and other techniques such as de-identification of data sets. Depending on the use case, it can be very effective, or it could strip out data that's actually incredibly critical for the purpose of the system. I was just recently having a conversation with a friend of mine in the health sector saying, if we could just get access to broad, robust, large data sets in the health sector that included clinical data, Even if you de-identify it, the problem is we still get, a risk of some re-identification. You can't de-identify with 100% perfection. So, even though we need that clinical data to be able to produce great outputs in the health sector using artificial intelligence, are we able to access that data in the current state? And so far, the answer is, if you really wanted large-scale data sets of clinical data, you probably would run up against some pretty severe privacy restrictions. So we're not quite at that stage yet. You can do it within a facility potentially, or within a particular health system, depending on how that data was initially collected. But if you wanted to take something that was a much broader data set, you would struggle, even with the privacy enhancing techniques that are in place today. So certainly we are seeing it, these techniques become more popular in the discussion on artificial intelligence and how we access data in order to train AI systems, especially in more sensitive use cases that would attract the kind of governance oversight that we see some of the emerging laws attempting to put in place. But we're not yet at the stage where certainly the privacy community or the risk management community or potentially individuals are comfortable having those techniques dominate and ultimately take over without greater governance in place and greater oversight.
That's great. And Soribel, you mentioned that funding opportunities were certainly one of the aspects of the order, and how the order could potentially impact the private sector. So are there other aspects of the order that provide funding and research opportunities for agencies and potentially downstream impacts to the private sector that you can speak to?
I can speak to one that is more of a pilot program and will only be fully funded if it's passed into legislation, and that is the NAIR, which is the National AI Resource. I'm forgetting what the other R is, but it's an NSF program. NSF has oversight over that, where civil society, academia, those non-industry, non-profit industries can have access to compute resources, to data, and to other resources that are needed that big companies have and take for granted, but that are very expensive and costly for nonprofit outfits, right? So that's one. And the other one is, it's not just funding, it's more about the opportunity for companies to have access to, human capital. And I think that is not necessarily monetary, but it's a very important resource that is unlocked if the agencies go ahead and change their visa processes, if they give priority to AI researchers and people that work on that, so that they don't have to wait 6 months for a visa appointment. They wait, let's say, a week or two. So that's not monetary, but that's huge.
No, that is huge. And I don't mean to interrupt you, but you're absolutely right. That's huge. And actually, members listening in today might be very interested in that. So if you could give a quick overview, I know we're sort of facilitating or streamlining the HB1 process for some of these specialized AI workers, but speak a little bit to exactly what that looks like and how private business can take advantage of that.
Yeah. So I'm a former consular officer, so I know quite a bit about this. But it's not just streamlining H-1Bs, but it's increasing the number of H-1B visas that can be given in any given year. It's also expanding to other types of visas. So, for example, O-1 visas are visas for extraordinary aliens. I don't like the word alien, but that's what it's called. And it's people that are world renowned, that have won awards. I'm talking about your actors and your Pulitzer Prize and Nobel Prize people. And those are visas that can be used to bring in, they don't have to go through all of those processes that H-1B has to go through. And they're much easier to obtain once you show that this person is actually someone who has extraordinary ability and there's no numerical limit on them. And so there's one more, which is J1 visas. There's a provision, it's called 212E, and that means that certain skills when students are here, and they come here on a scholarship for most of the time, if they have certain skills, then they have a 2-year provision where they have to go back to their countries. And so it would be kind of updating that so that these people that studied here don't have to go back like right after they complete their studies.
Yeah.
So not just H-1Bs, but other types of visas, and just make, visa appointments are a huge headache for businesses. And so making sure that these people get priority. Yeah, so I can talk more, but that's
No,
that's
it
really,
sounds like really allowing the United States and US businesses to be the leaders in advancement of AI technologies through international and global recruitment of sort of some of the best AI thinkers. I think it's a really important aspect of the order. One other aspect of the order as it pertains to privacy and protecting privacy has to do with data provenance, or sort of where is our information coming from? The order requires federal agencies to investigate and evaluate whether they're using what's known as commercially available information. Just this summer, the Office of the Director of National Intelligence actually declassified a report that was the government's first sort of public disclosure that it is in fact purchasing essentially large swaths of CAI and using it. Essentially, the justification was, listen, our enemies are using this information, the private sector is using this information. This is essentially sort of data broker information. It includes everything from just kind of consolidated public records all the way down to geolocation data potentially. So the order requires agencies to look at and investigate their use of CAI. It doesn't require any certain actions at this point, but I am curious as to whether either or any of you have thoughts as to whether or not we're going to see some potential regulation of commercially available information. And then taking a step back even further, I think it goes to the point of, we need to be looking at the personal information that we're collecting and whether we have the proper consents and authorizations in place. So Dr. Sridhar, I do want to turn it back over to you. When it comes to data provenance, when it comes to kind of PII, we have that patchwork. You talked about the patchwork of state privacy laws. I know businesses are just whack-a-moling away to try to deal with all of them. It's a bit of a headache. But is there anything they can do? Are there, whether through self-regulation, whether through voluntary processes, to address this issue of sort of data provenance and proper authorizations for the collecting of personal information?
Yeah, I think you raise a lot of good points about sort of the publicly available information dilemma that we are in the US, especially given our First Amendment rights and how the laws have to kind of tiptoe around that. The challenge here is that with regard to data transfers, and I'm gonna kind of go back to the solution again, because I think pets are a number one solution for this challenge. What we've seen in the laws, a great example is Colorado. I testified in Colorado's legislature last year when publicly available information and the derived data from PAI was under question, under scrutiny, and the Colorado regs. It was all about should we or should we not be able to have a personal information definition that includes that derived data, and therefore PAI would then be subject to data privacy laws. Consumer data privacy laws. I think where we came out was, there continue to be the First Amendment considerations that cannot be overstepped, but at the same time, we're getting into a more and more murky environment, especially as we saw in global privacy frameworks to date. There have been PAI has been subject to the GDPR and other restrictions. A good example of that was an article that came out, I believe, on one of the dating apps. I think it might have been Grindr or another. And it was very clear that that was that the derived data and the data that's being pulled from public data was subject to GDPR. And that was really interesting to see that case come out from the European Union. And I think the US stopped short of that, but we're looking and we're learning from the rest of the world and trying to figure out where we stand on these issues. Pets does play an important role in kind of helping unify this ecosystem and support further. I think it can really, increase cross-industry data sharing, allow for that standardization, especially across providing data transfers across data shared between these different countries, across the different data localization as well as data privacy regimes, and creates economies of scale for large as well as small companies that maybe don't have the bandwidth to be able to figure out exactly what's happening with laws.
Nice. And thank you for tipping your hat to obviously the global implications and the fact that there are international regimes to our United States audience. Carole, I'm interested in how the order is being perceived on a global scale. I want to mention that the order was actually issued the day after the G7 summit on AI and the issuance of that joint statement on the Hiroshima process for sort of high risk AI systems. And that process and that joint statement really calls for international coordination on the regulation of AI systems globally. So can you speak to what role, if any, the United States plays in this larger scheme of sort of global regulatory efforts to address AI, and then in particular, how the order was perceived?
I do agree with you that there are greater calls for international harmonization on AI standards, particularly to do with safety of AI systems. President Biden's executive order that came out 2 weeks ago, that was an important step in aligning where American priorities for AI regulation and ultimately AI risk management seem to align quite closely with other jurisdictions, as we saw in the UK through the AI Safety Summit and the resulting declaration, real importance being placed on the safety, security, and trustworthiness of these systems. The U.S. government and, frankly, U.S. companies are playing an important role in shaping the regulatory discussion for artificial intelligence. This has been true for a number of years now. Where domestically there have been a number of local laws that have percolated from city to federal levels, a number of executive orders to advance artificial intelligence in research and development in the U.S., to advance trustworthiness in AI systems, and then increasingly becoming more granular on where some of the risks lie. This particular order is interesting in that it specifically calls out dual-use technologies, meaning that there are some technologies, including foundation models, that may be used for civilian as well as military purposes, in which case they may be treated with a higher degree of scrutiny and concern, given the fact that they could be put to various different uses, some of which can be very harmful. Internationally, the U.S. is playing a vocal role, generally speaking, in aligning what those principles are for safe AI and certainly for what international cooperation on AI standards would potentially look like. It is also true, however, that the EU is probably playing the most aggressive role in shaping what AI law can look like. We all know the EU Artificial Intelligence Act is going through many different ongoing debates with the expectation to be passed in the next several months. An idea we're certainly looking for whether it will be passed by early 2024, and from there when it would come into effect, assuming it is in fact passed. So still a bit of a runway on that front, but it is the Europeans once again are standing up some of the most prescriptive law to shape how artificial intelligence, high-risk artificial intelligence systems will be used within their jurisdiction.
All right. Well, mindful of the time, I want to thank our panelists for their excellent insight into the Biden executive order. Any last thoughts, kind of predictions for the future? And certainly, Dr. Sridhar, as it pertains to the BBB national programs, I want to make sure we give you the opportunity to share how people on the call can take advantage of some of the BBB's resources that are out there. So I'll turn it over to you first before Soribel will jump to you for prediction.
Absolutely. And I should have mentioned, I mean, we have cutting edge programs on the privacy side as well as the AI side. So I'm happy to kind of just jump in and share a bit more for companies that are interested. So just to give you a quick history, so we've been around for about 50 plus years, help responsible businesses compete on accountability and consumer trust. We work to advance privacy best practices, as I've shared today, both in the pets marketplace, but also more broadly to secure consumer trust. And we provide a one-stop shop for trusted, cost-efficient solutions to all of the different competing state, national, and global privacy framework obligations. So we try to make it easy for businesses and build out uniform solutions to their compliance to the compliance hassles that are out there. Just a few examples of our privacy programs. Our KRU COPPA Safe Harbor program was the first FTC-approved COPPA Safe Harbor in the U.S. And so that certification and seal really provides weight to a lot of our emerging programs, including one of the programs I'm leading on teen privacy. In addition, we have a U.S. EU-US data privacy framework program, which is going to support all the data transfers that are happening globally, our cross-border privacy rules program, and want to touch on AI very briefly. A quick shout out to our CEO, Eric. He built the AI program from scratch 2 years ago, well before this conversation had even started in the US. And his experience in employment law really plays very well to this space. So what we had done about 2 years ago, our Center for Industry Self-Regulation facilitated a convening of industry leaders to develop best practices on the use of AI-enabled systems in hiring and recruiting. So this one use case is super interesting, similar to what Soribel talked about, trying to build out best practices for companies that are focused on a particular sector and make it useful to them, taking a risk-based approach. So we did 2 things. The output of that convening produced a series of best practices where we've transitioned that into a set of principles for trustworthy AI in recruiting and hiring. So happy to share more if anybody's interested or wants to learn more. It's also on our website. And we also put together an independent certification protocol for AI-enabled hiring and recruiting technologies. So both of those, happy to share more, but just wanted you to know that in the AI world and in the privacy world, we're definitely a leader and we hope to support companies across the space.
And I think the opportunity for certification, a seal, or self-regulation is really critical in the absence of that comprehensive data privacy law that I know we're all looking to Congress to pass. We can't read the tea leaves. However, we do have Soribel, who's on the ground and does have some insight. So really high level, Soribel, any predictions for 2024, not just as it pertains to AI legislation, which we already heard about, but what about data privacy legislation?
Yeah, well, I actually want to go back to, before I look forward, I want to look back. And one of your questions was, why now? Why is Congress so focused on this right now? And I just want to say that the government has been working on AI frameworks and legislation for a while. We just weren't paying attention to it. It wasn't publicized. If you remember, it was the Obama administration that put out an executive order on AI. And then the Trump administration built on it. So there has been work done on this, but it wasn't as public and as highly visible as it is now. For 2024, as you know, we have elections coming up. And not just US elections, we have global elections going on. The Senate may flip or may not. So there's a lot in play here. There's a lot of moving parts. I do believe that we can't have real AI legislation without privacy legislation. And I do believe that Congress members are more mindful that people want privacy legislation. People want protection for children. And state governments are actually taking the lead on this, which can be a good or a bad thing. But it's not a bad thing that states are looking at it and are putting pressure on our own Congress members to address these issues. So it's hard to say what's going to happen, but I do think that it's not going away, and we're going to have to address this privacy lack of regulations sooner or later.
Privacy is the foundation for AI. I happen to agree with that. And I think that certainly working on leveraging existing governance frameworks around privacy and seeing where you can sort of bake in AI to those frameworks makes a lot of sense for businesses. But we're very excited about the opportunities that this order may present through funding, through potential rulemaking and opportunities for public comment by the private sector. And I think each of you for your time. Carole, Dr. Sridhar, Soribel, thank you again for the wonderful panel presentation today.
Thank you so much. Appreciate it.
Take care.
Bye.